Oyez, oyez, oyez. The Honorable, the Supreme Court of Texas. All persons having business before the Honorable, the Supreme Court of Texas, are admonished to draw near and give their attention, for the court is now sitting. God save the state of Texas, this Honorable Court.
Please be seated. Good morning. Welcome to the Supreme Court of Texas. We'll hear argument in three cases this morning. The first is 220631, Boeing versus Southwest Airlines Pilots Association from Dallas County and the Fifth Court of Appeals. The second is 240040, Rush Truck Centers versus Sayer from Dallas County and the Fifth Court of Appeals. And finally, 240273, Cerna versus Pearland Urban Air from Harris County and the 14th Court of Appeals. The court has allotted 20 minutes for each side in each of these cases. We'll take a short break between the arguments, which can be viewed live online and will be available on the court's website later today. We're ready for argument in 230676, Cactus Water Services, Boeing against Southwest Airlines Pilots Association.
May it please the court, Ms. Johnson will present argument for the petitioner. Petitioner has reserved 5 minutes for rebuttal.
Mr. Chief Justice, may it please the court. This case presents two issues of statutory interpretation, one federal, one state. On the issue of federal preemption, the Dallas Court of Appeals became a national outlier by holding that claims requiring interpretation of a collective bargaining agreement may proceed in state court. That holding is contrary to the text and purpose of the Railway Labor Act and to numerous state and federal court decisions that have consistently found such claims to be preempted. On the issue of standing, the Court of Appeals correctly held that Texas's associational standing statute, under that statute, the Southwest Airlines Pilots Association, a labor union, did not have standing to pursue claims on behalf of its members when it filed this lawsuit. But the court erred in holding that belated pass-through assignments obtained from the pilots might fix the standing problems in a later suit. They do not, and this court should affirm that.
Can I take care of one issue real quick? I think the easy issue is, do you concede that SWAPA has standing to pursue claims on its own behalf?
We do, Your Honor.
Okay.
I don't think that's undisputed. And so for that reason, as to those claims, the court need only address the preemption issue.
Right.
Right. Yes, Your Honor. So as for preemption, for decades, the RLA has stood for one fundamental principle. No court, state or federal, can resolve a dispute that requires interpretation of a collective bargaining agreement between an air or rail carrier and its employees.
Now, you argue on this issue that the Court of Appeals confused the Adjustment Board's jurisdiction with preemption under the statute, that the Act preempts even if the Adjustment Board doesn't have exclusive jurisdiction. But if the Act preempts, isn't the effect of that the Adjustment Board is the only entity that can hear the issue?
Your Honor, you're correct. That what
so I don't see the distinction you're making in that argument because if you say that the court confused jurisdiction and preemption, and yet if there's preemption, there is no jurisdiction. It is, under the Act, exclusive jurisdiction.
That's correct, Your Honor, but what the statute says is that cases requiring interpretation of a CBA against third parties like this one, there's no preemption.
The statute doesn't say anything about preemption.
We believe that's encompassed in the purpose of the statute, Your Honor, in section 180,
so you're making an implied
151A.
conflict preemption argument, right? That it stands as an obstacle to the purposes that are recited in 151A?
That's correct, Your Honor.
So we're pretending that we're going to divine what Congress's purposes are here. That's what Justice Blackmun was doing in Norris. That's what we're supposed to do, is put ourselves in the minds of the policymakers and decide what they meant, even though they didn't speak to preemption.
Your Honor, we would say you don't have to define it in this case because it's textual. This is not a situation where you have to look at legislative history or anything else. The purpose
Well, it says to
is
provide for the
expressly
prompt
stated.
and orderly settlement of disputes, but I take it your position is that the the adjustment board doesn't have jurisdiction to resolve this dispute, is that right?
That's correct, Your Honor.
So
This
then
case-
how would a court deciding this, not deciding this case, provide for the prompt and orderly settlement of a dispute that the people that you say have exclusive jurisdiction don't have jurisdiction to settle?
Well, what the authoritative gloss of Norris and all of the cases say, and what all the LMRA cases say, which is an identical preemption standard, is that there is a remedial gap, and this case falls into it.
Well, I haven't seen anything to that effect in the U.S. Supreme Court precedents. Can you point me to that?
Well, Your Honor, I would point to that's not, the remedial gap is not discussed in the Norris case, no, but it is discussed in many of the cases.
Which are not binding on us.
Not binding, correct, Your Honor. That's true.
So Norris talks about that that this is a comprehensive framework for resolving labor disputes and a mandatory arbitration mechanism for prompt and orderly settlement of two classes of disputes. And I guess I'm just having trouble understanding, if there is no mandatory arbitration mechanism for prompt and orderly settlement of this dispute, how is it within the purpose clause to say that, well, because there will be no settlement of this dispute if we say there's preemption?
Well, let me just be clear about this. The specific claims that have been brought by SWAPA do not have a forum. They fall within the remedial gap. That does not mean that these employees, the pilots, don't have a remedy. They do have a remedy, and they have a remedy against their employer, and that's what the RLA contemplates. And so
But if the pilots had sued individually rather than creating the standing issue, the associational standing issue, if they had sued individually by name, your position would still be that that their claims are preempted because it would require construction of the 2006 CBA, and that they would have no remedy at all. They just couldn't. There's no way they could ever pursue their claims
against Boeing, correct?
against Boeing.
Against Boeing. That's correct, Your Honor. Federal
That's really a
preemption
strange
can and
concept.
does. Yeah, Your Honor. I mean,
the concept of federal preemption is that rather than state law governing, federal law governs and provides the remedy. And yet your position is here, federal law deprives the parties of any remedy.
that's correct, Your Honor. And
strange.
let me give you some cases. Federal preemption can and does extinguish state tort rights and create a remedial gap. That's Sears versus Newkirk.
Sure,
This
no
remedial
question it
gap
can
is
do that if you're talking about field preemption or someplace where Congress is speaking to displace state law. But to divine that from a general purpose clause that's talking about the purposes of this chapter, and then when you look at the rest of the chapter, there's nothing in there that would touch on this at all. And in fact, you concede that there's nothing that they could do under the RLA to resolve this dispute. It just seems like an incredibly broad reading of
And not
language.
only that, 151A specifically says that it's to provide for settlements of claims related to CBAs.
That's right.
And
That's right, Your
so-
Honor. But the problem is, and again, I encourage the court to look at Sears, to look at Mohammed, to look at Kimbrough, Covenant Coal. These are all cases that recognize if a party chooses to bring claims against a third party, a non-signatory to the CBA, that those do not have, there is no forum for those claims. And that is because
I would
Congress.
find would those be in the U.S. reports, is that right? Or also the Southwestern Third?
Those are all federal cases,
Okay,
Your
got
Honor.
it. Okay, so I guess my question is, in the statute, in the United States Code, sorry if it's a dumb question, but which of the language should I be looking at here?
For the
For the
scope.
preemption? Is
the
it
scope-
something other than the purpose clause that the Congress enacted?
Your Honor, we would submit it's the entire statute.
whole thing and
It's
we'll-
the whole thing.
Got it.
Read together, what this statute stands for is all claims that require interpretation of a CBA are preempted, and claims between carriers and employees are subject to adjustment boards. And there is a remedial gap for a very few cases. Let me be clear. This is not a big remedial gap, but it's recognized in the cases that we've given to this court. And it makes sense in terms of the RLA's goal, which is uniform interpretation of CBAs while ensuring that parties to the CBAs participate in this proceeding.
But
If
you're
this-
arguing for no interpretation, not uniform interpretation.
We're arguing here, Your Honor, that what should not happen, and what the RLA says and what Norris says, is that it should not be decided in a Dallas state court in which Southwest is not a party what their collective bargaining agreement means. And make no mistake, that is exactly what SWAPA intends to do. This labor union wants to go into a state court and have collective bargaining agreements interpreted in proceedings to which the employer is not a party. And that is the overarching goal of the Railway Labor Act. It's the overarching goal of the LMRA, which is an identical preemption standard. And all of the cases that interpret these statutes recognize that a federal preemption does not guarantee a cause of action. And here—
Well, the cause of action, we don't need a cause of action from federal law. They've got causes of action they pleaded under state law. And Norris seems to say that the question is whether the duties or rights that are being asserted are created or defined by the collective bargaining agreement. And the duties and rights that are being asserted here are all from state tort law. So yes, you may have to interpret incidentally the collective bargaining agreement maybe, or there's arguments on the other side that not. But even if you did, why shouldn't we focus on where the duties and rights are coming from? And as long as they're coming from tort law and not from the collective bargaining agreement itself, it seems like there's a lot of language in Norris that would say no preemption.
Well, Your Honor, let me be clear. These are claims that arise directly from the collective bargaining agreements. The claims in this case, tortious interference, fraud, all claim we did not have an obligation under our prior collective bargaining agreement to fly the 737 MAX. And because of you, Boeing, we agreed to that in the 2016 CBA. So it is absolutely going to require interpretation of what the employee's obligations were under a CBA.
But that wasn't my question. My question is whether the preemption focuses on where the duties or the rights come from that are being asserted. And don't those come from state tort law and not from the collective bargaining agreement? And you're just looking at the collective bargaining agreement, if at all. And I understand the other side says you don't have to look at it at all. But assuming you're right that we have to look at it for some things, aren't we just looking at it to decide whether what they said was false or misleading? And so that basically it's a breach question. It's not a duty or rights question. The duties and rights are coming from state tort law.
No, Your Honor, I disagree with that. And I would ask the court to, based on the court's most recent pronouncement of tortious interference in the Inwood case, this court needed to, the first element of a tortious interference claim is determine what are the legal rights under the contract. And that determination here, how that maps onto this case, is it's a determination of what these pilots' obligations were under a CBA.
Let me test this a little bit, because this the one thing I'm most confused about in this case is the proposition that for the pilots to prevail, the court has to construe one or the other of the CBAs. And so the 2016 CBA, nobody disputes that it requires them to fly the MAX, right? So there's no need to construe the 2016 CBA. Everybody agrees what it means.
I disagree. I think there is reason to still construe the
And why is
2016
that?
CBA. Well, you have to construe how it was different from the 2006 CBA.
Okay, well, that means you got to figure out what A means and what B means,
Right.
and then compare them. We all know what B means.
I think, Your Honor, let me just add, you also have to decide what other advantages did these pilots get in the 2016 CBA in return for agreeing to fly the 737 MAX.
Is that you mean like a damages question?
Yeah, it would go to their reliance and damages.
I haven't seen anything in the record of the briefing that suggests there's any dispute about whatever benefits and advantages they got out of the 2016 CBA.
Oh, very much so, Your
And
Honor.
they do admit that, I mean, everybody concedes that it requires them to fly the MAX. Right?
That is correct.
Okay.
Everybody concedes that it requires them
All
to
right.
fly the MAX.
But let's go to the 2006 CBA, because I'm still struggling with that. If whether the 06 CBA required pilots to fly the MAX, SWAPA believed it didn't, right? And refused to fly the MAX under the terms of that agreement, and even sued Southwest to challenge that construction of the agreement. But then it agreed, it alleges, in reliance on Boeing's misrepresentations, it agreed to fly the MAX, right, in the 2016 CBA. So now here's where, and I'll have questions for them, and the causation and damages theory is weird to me here, but maybe that's not a jurisdictional issue. But But it says you harmed them, pilots say you harmed them by making misrepresentations that caused them to agree to fly the MAX, which they didn't want to fly, but then based on those representations, decided they did want to fly, and then they couldn't fly it because it turned out not to be a good plane, and so they lost money, right? So causation and damages is weird there, but in any event, it all comes down to you caused them to agree to fly the MAX regardless of whether they had ever agreed to it before or not. So why does it matter whether they had ever agreed to it before when their claim is you caused them to agree to it in the 2016
And
CBA?
if I could answer this just on the tortious interference claim, again, the Inwood case, first element, what legal rights did you have that were subject to
They're not claiming
interference?
that you interfered with their rights under the 06 CBA, are they?
They are claiming that we induced them to give up something, to give up a right, an obligation that they didn't have in the CBA and take it on in the 2016 CBA. They are claiming they gave up rights in the 2006 CBA, and we're saying, or the position would be, you didn't have those rights to start with, so there couldn't be any tortious interference because you were already obligated. So the issues would be, what planes were the pilots obligated to fly? What specific planes? Were the specific planes enumerated? Was that an exclusive list? Were they obligated to fly the whole 737 family of aircraft? And that will be absolutely the threshold of any tortious interference claim, because the court would have to determine, a Dallas state court would have to determine what legal rights did the pilots have that they may or may not have given up in a later CBA.
So zooming out just a little bit, one of the other purposes stated in the act is to avoid any interruption to commerce or to the operation of any carrier engaged therein. If parties to the CBA, and let's just for a second, every pilot is a party. But say it's a railroad worker, or if they are able to sue and assert state law claims against a party that does business with the employer, does that create the kind of interruption or interruption to commerce or to operations of the carrier, such that it's a dispute growing out of the interpretation of the agreement? So that's one side of it. The other side, though, is if the third party has caused some injury to the worker, why would the worker not be able to sue? For a product defect for a rail car that's provided, for example.
To the court's first point, absolutely, and that is the reason why every court to address this issue has held that it doesn't matter if you bring your claim against a third party or a non-signatory. If it involves interpretation of a CBA, it's preempted. Now, to the court's second point, absolutely, a harmed worker could bring a claim against a third party if it doesn't involve interpretation of a CBA. These pilots can sue Boeing for non-CBA related claims if they have them, but that's not what they've done here.
Can I ask one more question? Thank you, Chief. To cut to the chase, I'm going to characterize your argument, and you tell me if this is wrong. The RLA doesn't say what you say it says, but the U.S. Supreme Court and other courts have said it says that, and therefore we should follow it. Do you agree? Because it doesn't say, well, more importantly, it does say in 181 and the other sections that respondent cites to, it does say, it identifies not only what it applies to, but who it applies to carriers and employees. And you're saying ignore that because the U.S. Supreme Court has ignored it. I'm gonna couch it in the most argumentative form.
We're not saying ignore it, Your Honor, first of all. We're saying to read the whole statute together there's only one way to read it, which is it preempts all disputes, but only disputes between carriers and employees go to an adjustment board. And there's a remedial gap in which a very narrow group of claims, like this one, a claim against a non-signatory to the CBA, let's go to a state court and have them determine what a CBA means when the employer isn't there. That the danger of that is so great and so bad and so against Congress's purpose in developing a uniform body of law interpreting CBAs and allowing participation in the proceeding by the employer. That is the part that I think there's just no way to square their reading of the RLA with what this means for employers. So now,
So why shouldn't we just abate and let you join Southwest, and then y'all can pursue whatever exclusive remedies you want in front of the adjustment board, and then the exclusive jurisdiction is satisfied, and then it comes back and the state court decides the rest of the case?
It's just not the way it works, Your Honor. You don't toggle back and forth between an adjustment board
Well,
and a
that's
state
exactly
court.
Can't we
the way that
decide how we just say how it works, or is
Well,
that not the case?
I get, to be clear, there's no precedent for going to an adjustment board. And let me just be clear, we're in this situation because of the deliberate procedural choices that this labor union made and how they brought this lawsuit. So there's no precedent, there's no procedural precedent for us joining Southwest or going to an adjustment board and then coming back to state court.
Well, that's because the statute doesn't apply to this circumstance. But, I mean, I understand your point, but we've said in exclusive jurisdiction cases in state court that that's exactly the way it works. We abate for the agency that has exclusive jurisdiction to do its thing, and then it comes back.
And I would say here, Your Honor, that in that situation, in exclusive jurisdiction, you have a plaintiff who has no remedy whatsoever. We say these pilots have a remedy. It's against Southwest. And to be clear, I want to be clear about this. They've already gotten that remedy to some degree. They've already received money from Southwest Airlines that represents their financial damages for the grounding of the 737 MAX. Southwest said they settled very early with Boeing. Boeing made a large payment in settlement, and Southwest said, we're giving $125 million of that settlement to our employees. And so these pilots have already received compensation. So to be clear, it's not that SWAPA, it's not, they chose to bring this lawsuit in a very unusual way, to bring CBA-related claims against a non-signatory, to do it through these belated pass-through assignments, to high-pressure litigation tactic to get their pilots to sign on. And now they find themselves in a situation where the only result is dismissal with prejudice because of the procedural choices they made and how they brought this.
Any further questions?
Just one more, but when you come back, if there's anything in Article 6 of the U.S. Constitution that supports your argument, I'll be curious to hear it.
Thank you, Your Honor.
Thank you, counsel. We'll hear from the respondent.
May it please the court, Mr. Cole will present argument for the respondents.
Morning, may it please the court. I think there's agreement, oddly enough, on kind of the big picture question between my side of the table here and Boeing, that there's a policy purpose to this preemption doctrine. It's not just words and you try and match it up. It has a goal. It's trying to do something. The dispute is, what is that goal? What is it trying to do? And that's what I think the questions we're getting at this morning. Our position is the answer to that question, why is there preemption, is tied to what the statute specifically says. And what it says, we say it in our briefing, and I don't want to belabor the point, but it's clear and it's plain. It talks about disputes between carriers by air and their employees. Another section talks about similar things with railroads and their employees. And after that initial statement, over and over again, and I think there are 3 different variations of that, it creates an ADR mechanism, arbitration, mediation, these adjustment boards, and so on and so forth. What the statute is a giant arbitration encouragement machine for disputes between air carriers and their employees. That's the policy purpose. Get those cases to arbitration, to adjustment. And when the statute at the beginning of that section talks about this chapter, that's what's in this chapter.
What if it's a carrier but not an employee, or an employee
Right.
but not a carrier? How does I know you cite cases, and you basically distinguish this case on the fact that it's neither nor.
Right.
But what if it's one and not the other? What language in the statute tells us the answer there?
So the cases have had to fill in some gaps in the statute here, because all the statute says is carrier and employee. There are cases that have involved
Because
non-parties.
we're just trying to figure out
Right.
what the
Well,
purpose of
here's
Congress
the
is
pattern.
without any statutory language to tell
Right,
us.
so that's a problem. We're trying to play guesswork, and we're doing it with no Texas cases, no U.S. Supreme Court cases really, and kind of a hodgepodge from around the country. But there's a pattern to the hodgepodge. And the cases that are cited by Boeing about this all involve one of two fact situations, generalizing. They involve someone trying to get around the RLA arbitration by suing an agent of the airline. There's lawsuits against employees or the boss or a private investigation firm or somebody who, while nominally distinct, really is the airline. And so, okay, nice try, but you're really the airline, is the way the cases resolve that.
Like the one against the airline's insurance carrier, you would put that in that category?
I put it in that category. It was a claims processing thing. They sued the carrier and some people that were involved in the claim. The employer had outsourced claim handling to some private concern. Happens all the time.
But do you concede that it doesn't apply to suits dealing with third parties? Do you concede that?
I believe firmly that it doesn't. And I don't think that's crazy. Cases go to there are frequently disputes outside of this sort of rarefied air of the Railroad and Airway Preemption Act, where you have claims that are in arbitration and claims that are not in arbitration. That happens all the time. I've got an arbitration agreement with X. I don't have one with Y. I just go. I've been wronged by both X and Y. And that creates some case management issues sometimes, and the arbitrator and judge need to check in with each other, but that happens frequently.
But getting back to the example, or to the question of if there's one but not both,
Right.
carrier and employee involved in a dispute that does require construction of a CBA,
So,
then in the most argumentative way possible, it sounds like you're arguing that the statute doesn't say so, but the courts have said that must be arbitrated, so we should follow those courts.
I think here's I have two different ways of coming at that question, because I've thought about it a lot. Let me finish the cases for a second. The cases they cite either deal with employees of the airline or a successor to the airline. There's like a new company comes on the scene, but it'd be like a new, like Frontier gets bought by America West or something like that. So all these cases are really cases about airline or employee, just nice try, guys, nice gimmick.
Essentially, the claim is against.
Exactly. I
So it's
thought
both.
it's that's
Employee
right.
and airline
Yeah,
affected.
you tried, you didn't succeed. Now, the way I've come at it, we briefed this saying there's a threshold question of whether it applies, and then there's a question about what the effect is if it applies. And the more I've thought about it, I think that may be a little off from how I think it works in practice. Both of those questions, does the law apply, and what is the effect if it does apply, are driving towards the same thing, implementing this statute, right? It's the same statute, it's the same command. And that's where I think the word interpretation has taken on a little life of its own in some of these cases. You have Norris and you have the cases we cite that deal with the construction of the statute to the non-airline, non-employee cases. You have other cases over here that have kind of gone past that and jumped right into, well, what do we have to do with the CBA? And they look at it and they kind of hold up an interpretation meter and say, well, are we interpreting or not? They tend to distinguish between interpretation on the one hand and reference or evidentiary use on the other hand. That's interesting, but I think it's beside the point. I don't think you're interpreting a CBA unless the people involved in the CBA are there. In other words,
We often apply direct benefits estoppel when one party is asserting rights.
Sure.
Contract rights that otherwise would have to be arbitrated.
Right. Nowhere.
And so I understand Section 3 speaks specifically to carrier-employee disputes, and so that's some indicia that this is a limited adjudication method for grievances between carriers and employees. But I think their side says, well, that, yes, for those specific disputes in Section 3,
Right.
it's standalone. And they say, but the purposes of the Railway Act are broader, which is to confine disputes to the employer-employee, to equalize their bargaining power, to preclude disruptions to interstate commerce. And so how does the very narrow interpretation that the Court of Appeals gave the act, which is to say, all you do is identify the parties. If the parties are the employer and the employee, Railway Act governs. If they're different, it does not govern. You don't even look to whether the claims involve interpretation.
Well, our position has always been, you look to, is it arbitrable? And that answers the question of, are you interpreting? And answers the question, does the act apply? In this business about a remedial gap, for one thing, the U.S. Supreme Court, not to be found, not in this area's decisions. If you look at them, and again, these cases about remedial gap, they're saying you don't have a state law claim against the employee, against the successor. The only case I found in their list of authorities, there's the same 8 cases they cite in the middle, is this Healy case, where they said there's no claim here, we recognize you don't have a cause of action, we acknowledge that's a consequence of this, because the employee didn't go through the grievance process under the CBA. It was an argument about a remedial gap that said you need to honor the CBAs.
But I think they do look at, and leave aside the question of the gap, they look at, they say, is the claim growing out of the interpretation of the agreement? And will it affect the operations of the carrier, which in turn has an effect on interstate commerce, which is the concern, with different interpretations of that agreement.
So I agree that the test is, if you pull the test out and just look at the test, you can support that argument and say, well, it's looking generally at what the CBA does. On the facts that they apply them to, that's not it. They're never applying it to a case like this, where we're suing a third party that has no relationship to the airline, not their employee or successor or something like that. It just doesn't happen. So I admit there's some loose language in these cases that talks about interpretation generally, and it talks about the policies of the act. But it has not been applied in those cases to bar a claim like ours. And I think part of the problem is Norris is what started all this. It's the word from the Supreme Court on this. About half of Norris talks about the adjustment board stuff, and about half of it talks about the preemption test. And over time, people just started citing the preemption test without referring back to the structure of the statute and the arbitration agreements, which is what gives rise to this loose language.
But if it's trying to ensure adequate bargaining power, does really giving the ability to sue based on the collective bargaining agreement, sue a third party based on the agreement, and that third party is the predominant supplier to the employer, that seems to involve the bargaining power of the two parties. And so that's where I'm kind of...
Yeah, no case has done that and applied it to that. We cite cases to the contrary, and we're not enforcing the collective bargaining agreement. That was the questioning earlier. We're here posing a hypothetical. Like, what should we have gotten in a lawsuit against Boeing, who's not a party, and what we got, based on what you told us, what we thought, how we responded.
Southwest?
Southwest has never been a party to this case.
Repeat what you just said. The hypothetical is, what should we have gotten?
We, the pilots, we should have gotten X, and we got not X.
You should have gotten X in what?
In flights.
In the 2016 CBA.
Correct, and all of our claims are based on the 2016 agreement.
So I get your duty and breach allegations. Would you explain your causation and damages theories?
Simple enough. I mean, what you said something to us. We relied on that. That caused us to enter an agreement that one was advertised. We bought the bad car. We bought the bum steer. You said it was going to have these properties. It had these properties.
But their argument is, okay, yeah, you bought the bad car. You bought the lemon. But 6 years earlier, you had already bought that lemon.
I'm mystified by that because, for one thing, that's not what we say. Well, that's not an element of our claim anywhere. It's sort of a defensive argument they're making.
At a minimum, it's their defense. Hold on.
Yeah.
At a minimum, it's their defense. You sue me for misrepresenting the qualities of this lemon that you bought from me. And as it turns out, you bought that lemon from me years ago.
Yeah,
I mean, why can't I, at least as a defense, raise that and make it a relevant material issue in the case?
So two things. You can raise it, I suppose, but that's not the standard we use either under state or federal law to evaluate whether there's preemption. But on the merits of it, I'm talking about,
That's confusing concepts. There's preemption under your theory. You agree there's preemption if it requires construction of a CBA, but only if it's between at least one, if
Right.
not both parties. And so what I'm questioning is, maybe you win because it just does, as you argue, it doesn't require, regardless of who the parties are, it doesn't require construction of a CBA. That's your argument. I'm struggling with that because if in fact, at a minimum, it's their defense that you didn't buy a lemon from me, you had already bought the lemon, then doesn't the resolution of the case require construction of the CBA?
yeah, so assuming that construction of the CBA means something other than what it means under our view of what the statute says, I don't think so. The element of our claim is that fraudulent inducement stands alone. You told me a lie that messed up my thinking process. I wasn't able to make an intelligent decision. That decision had consequences. That's the framework.
So
It's
the
looking forward.
consequences, you said you bought the bum steer, but didn't Southwest Airlines buy the bum steer?
Well, we bought the bum steer by
Right,
agreeing
and
to fly
so
the bum
your
steer.
damages
Ride
in
the
this
bum steer.
case are not for the bum steer, they're for pay that you were not entitled to.
True.
And doesn't the act in the statute itself say agreements covering rates of pay?
Yeah, but we're not-
And your
yeah.
argument is, we agreed to one standard that was entitling us to this much
Mm-hmm.
pay, and because our employer bought the bum steer, we didn't get that pay,
So
right?
our calculation of tort damages is a calculation of tort damages. If somebody tries to go to court or to one of these adjustment boards and say, hey, look, I got some finding about damages that was made, no go. That doesn't bind anybody. Nobody's ever suggested that it does. It's a separate thing. It's what our cases call either an evidentiary use of the CBA
So
or
you're
reference
not
to the
invoking
CBA.
the agreement to show, here's
Yeah.
the pay that we forewent?
Yeah.
So what are you invoking then?
well, it's-
Because if if there's a product not on a shelf, and I would have used that product in my business to make more money, do I have absent a contract or some other sort of agreement, do I have a right to say to the supplier, well, you didn't supply my grocery store with this, and because of that, I lost money in my business?
Well, so the claim is Boeing promised the sun, moon, and stars to us directly, by the way. We received those. We didn't get the sun, moon, and stars. Part of the sun, moon, and stars is what ended up in the CBA. That's an evidentiary use of the agreement under those cases, and in the statutory interpretation context, it doesn't qualify as an interpretation.
And that might be right, but I'm just wondering about the damages.
Yeah.
Are the damages the flights that you didn't get to make, and so you didn't get paid for those, or what are
That's
the?
a big chunk of them.
Okay.
So your causation and damages theory has to be that if you had not agreed to fly the MAX in 2016, Southwest somehow would have had or at least have been required to provide other planes that would have had you flying as many flights as you thought you would be flying.
That's what the record shows. They had a fork in the road. Do they buy Maxes or do they buy some other plane? They chose the fork. By the way,
Do
back on
you need to prove,
Go ahead. I want to talk about
I'll give you time to say whatever it was you're about to say. Do you need to prove each individual pilot's reliance and inducement in order to recover each individual pilot's wages?
I don't know. But certainly the amount, the quantum of damage is going to be different for each one. The evidence is going to be largely the same. So I don't think 8,000 people are going to have to testify. So I don't know exactly how it would be proven. I do think at the end of the day, you probably would have to have something to say about individual reliance.
You can see how the association, in theory, may have been induced to agree to this or that in the collective bargaining process, but it might be more difficult to demonstrate that the pilots themselves made decisions about their careers or their participation in this arrangement based on representations that you're talking
Yeah,
about?
I think the record shows consultation between Southwest and the union, or between SWAPA and the pilots during the course of this negotiation. So we were relaying, the union was relaying what it heard, people were responding back. It's not like they were just, out there somewhere. So they were, I'm not saying every 8,000, all of them were in the room when these statements were being made, but they were part of it in an individual fashion through that, more than just us being.
The
But anyway, we're a little bit, about this darn 2006 thing, okay.
And so this goes to the associational standing and the assignment question. I mean, even if the assignments are valid, if you need, so you've been assigned, 8,000 different individual cases. If you have to prove 8,000 individual cases on a case-by-case basis, then there's,
Well, it's
I assume that's what you're trying to avoid, but that may be all that assignment on its own gets you.
Look, that's a case management issue. 8,000 people have got a claim here. And whether they all line up and we have 8,000 trials, or we have it in one, or we break it apart in bellwethers or something, that's a case management issue. It's not an issue about whether the assignment's valid. I mean, this court's never held that. But just having a lot of assignments creates some kind of problem. So that's true. There are management challenges, as there are in any mass tort. That's because they told lies to a lot of people, is our view. But that's not a disqualifying issue on the front
So
end.
if a
Something we'll deal
lawyer
with in
wanted to
trial.
create an LLC and then ask people who are injured as part of a mass tort to assign the claims to this LLC, all aligned, no kind of Mary Carter or other problem, is that something that we've recognized before?
I don't think you have. I don't think that this case raises that question, because your Southwestern Bell precedent focuses on whether the large entity is aligned with the individuals, and there's no question SWAP is aligned with these people. We're claiming the same representations. We're claiming basically the same type of injury. It's not a question of some newly created alien entity. It's someone that was in the trenches with them at the same time and has basically the same claim. We have alignment. Your hypothetical raises a unaligned entity, something under the control of the lawyer in some way that we just don't present here.
Let me get back to the test about the preemption. Some of the language in Norris talks about whether the duties or rights are created or defined by the CBA. What's your view of how broad or narrow that is? Are the duties and the rights here the ones that are created by state tort law? And in other words, if all we're looking at is whether we have to interpret the agreement to decide the duties or the rights, we need to know, well, what are the duties or rights here? So is that just, do those all come from state tort law?
Yes.
Or are there some duties or rights here that grow out of the agreement?
They all come from state tort law. The CBA is relevant. It is evidence as to some of those, but the source of the right, the reason we have a claim, emanates from state common law.
So it may be a defense, as Justice Boyd said, to some of the elements, but the duties and the rights themselves, in your view, are coming from state
That's my view,
common
and we
law.
detail it in the briefing. And can I say one thing about this 2006 CBA
Sorry,
thing?
Counsel, I've got just one, I've got a dumb question for you too, if I may, Chief. I thought I understood what your argument was, but now I'm not so sure. In your intro, so I assume that you chose the words advisedly, use the word goal, that both sides agree and just disagreeing about what the goal is. So would you say that as you're using the word goal here, is purpose a synonym for goal there?
Statutory purpose.
And so would you say that your argument and your friend in opposition's argument, you're both making purposivist arguments rather than textualist arguments?
No, the text defines the purpose. I mean, I think that
Sure,
we have to look at the text. What are we trying to achieve here? And when you have 5 sections, all of which talk about the same thing, that suggests that our goal is to probably do that thing, is all I'm saying.
Well, Section 3 talks about the adjudication of grievances, but the purposes talk about all disputes growing out of grievances. And so I think I'd completely 100% be with you if it stopped there, but it says, or out of interpretation or application of agreements covering rates of pay.
So it says purposes of this chapter, and it lists a whole bunch of purposes of the chapter.
I think it says of the act.
Well,
The purposes of the act.
chapter.
I may not be looking at
yeah,
the right.
the language that, well, let me
What do
find.
the statutes at large say?
I have this list of statutory goals as part of a longer sentence that describes the purposes of this chapter, citing USC 151A. And unfortunately, on my page, I just have some excerpts, but I think my argument is in context, either because it says so expressly about the chapter, or because what comes next is a whole bunch of detail about one thing. It ends up in the same place.
But did you just cite the U.S. Code?
I did.
What do the statutes at large say?
I don't know.
Okay.
Chief, sorry. We made her go over time.
That's all right.
Say what you wanted to say about the two
Oh, those things.
2006
I
CBA.
It just bugs me. Their argument is if we'd told the truth earlier, something would have happened, right? That's their causation argument. 2006, but if they'd told the truth earlier, there wouldn't have been a problem. I mean, there wouldn't have been a case. It doesn't have any bearing on what our claim is. Their counterfactual thing about, well, we would have fallen back to 2006. Why? If they're saying at that time we made a lousy plane and it falls out of the sky, we wouldn't have fallen back to that agreement. There would have been something else would have come along. It just doesn't add up. Their argument is the minute we fess up, 2006 pops up and off we go and we got to interpret that. That's not a given at all. And there's no evidence about that. One last thing, if I may. There was a statement made about us getting a bunch of money from Southwest, not in this record. What's in this record is a press release that talks about all this money we're going to get. There's not evidence in this record of a dime that got its way to us, and I'm not standing here trying to get double recovery. I'm standing here because we have valid claims. So that claim needs to be footnoted back to what it is, which is a press release without a supporting document. Thank you.
Any further questions? Thank you, Mr. Cole. Ms. Johnson, I believe you have 5 minutes.
Thank you, Your Honor. Let me begin with addressing Article 6, the Supremacy Clause. That is, Your Honor, that's the basis for preemption in this case.
But I'm sorry, which words there? Was this the Constitution or laws of the United States?
It's the law. It's the fact that the RLA, as the laws of the United States, preempts claims that conflict with it. And here we would say state law claims that require interpretation of the CBA conflict with the RLA. And so the RLA preempts. Let me just address quickly, if I may, Norris. Our point on Norris is that, yes, when the U.S. Supreme Court interprets a federal statute like the RLA, its interpretation or gloss is authoritative on this court.
Well, but it's distinguishable, right? Because in Norris, they had an employer and employee, so it doesn't really inform this kind of lawsuit, which is one side to the CBA and not the other.
It doesn't directly, Your Honor, but it does in this sense. First, it says that the key inquiry is the nature of the claim, not who the labor union chose to sue. And so that what they are asking this court to do is to create an exception to Norris, to say, well, yes, Norris says you look at the nature of the claim, but except if you choose to sue a non-signatory, it's a different rule. So we would say it's an exception, Norris. Second of all, Norris makes very clear that it is importing the preemption standard from the LMRA, which it says is virtually identical. And the LMRA is absolutely crystal clear on this, that there is no cause of action, no federal cause of action for interpreting a CBA against a non-signatory, and it simultaneously preempts the state law cause of action.
Which section is that of the code that's clear on that?
Your Honor, I don't have the section of the code in front of me, but let me point the court to the Fourth Circuit opinion in Covenant Coal, the Seventh Circuit opinion in Kimbrough, and this is a quote. There is no injustice in finding, it's section 301, Your Honor. There is no injustice in finding that section 301 of the LMRA serves as both a bar to a federal cause of action for tortious interference with a collective bargaining agreement against a non-signatory and to preempt a similar cause of action based on state law. And what Norris says, which is binding on this court, is that the preemption standard in the LMRA is identical to the preemption standard in the RLA. And we submit that what SWAPA is asking this court to do is to become an outlier, for Texas to be an outlier and provide a roadmap really for plaintiffs seeking to avoid federal preemption in the labor context, because this will be coextensive with the LMRA. It sets a dangerous precedent that Congress intended to prevent. It opens the floodgates to conflicting interpretations of CBAs under a multitude of state and federal laws with different jurisdictions that have vastly different views of an employer-employer relationship.
And those sound like great policy arguments for Congress, yet none of them were put to bicameralism and presentment.
These policy arguments, Your Honor, are set forth in the purpose of the RLA to cover all disputes and the authoritative gloss of the U.S. Supreme Court in the Norris case. That's exactly why Norris says the key inquiry is the nature of the dispute.
I thought it said it was the question of whether the duties and the rights are created or defined by the CBA.
And Your Honor, the duties and exactly, do the claims arise from the CBAs? And Your Honor, again, tortious interference claims have uniformly, they haven't given you one case where a tortious interference claim against a non-signatory that is based on purported legal rights in a collective bargaining agreement has been permitted to proceed in a state court, because there aren't any. This case will be the first, and it will open the door to forum shopping by lawyers looking for a different interpretation of a CBA than one that could obtain from an adjustment board. And the potential for inconsistent interpretations is heightened by the fact that the employer will not be party to this proceeding in Dallas State Court.
But the employer won't be bound either, right? If there's an interpretation of the CBA in a case to which the employer is not a party, does the employer have to do anything in connection with that interpretation?
I mean, Your Honor, we're open. As I said, this is an issue of first impression. I don't think there's an answer to that, because this has never happened before. We don't have a single case that gives us a roadmap for what to do here.
If we have to read a bunch of judicial opinions, there's all sorts of offensive, non-mutual, collateral estoppel opinions and Wright and Miller and everything. I mean, if you want us to read judicial opinions, we can go read them, or you can send us more briefing about that. But there has to be a first time for something sometimes.
Well, I guess I would just close, Your Honor, by saying that this Court of Appeals opinion makes Texas an outlier, and that it goes directly against the congressional intent of creating a uniform and consistent body of law interpreting CBAs.
Any further questions? Thank you, Ms. Johnson. Thank you to all counsel. The case is submitted, and the court will take a brief recess.
All rise.